Yeah, because we shut down that. We're still sending you. Everybody's on there again. Lieutenant Gill? Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard.
Good afternoon, everyone. Sorry, the plexiglass is like impeding my view. I want to welcome everyone back to the Appellate Division First Department, back from your summer vacations, and some of you back to the courtrooms for the first time in a while. I would also like to welcome our newest, one of our newest justices here in the Appellate Division, Associate Justice Bahati Pitt, who is joining us today for her first oral argument. Justice Pitt is a judge, or was a judge, from the criminal court appointed in 2016 in Bronx County. Prior to her appointment to the bench, she served as a principal law clerk in the Civil Division of the Bronx County Supreme Court. She also served as a court attorney for the Bronx Family Court and the Bronx Civil Court. Prior to that, she worked as an attorney with the Criminal Defense Division of the Legal Aid Society. Actually, where I first met Justice Pitt, where she appeared before me as a legal aid attorney. She earned her BA from Morgan State University and her JD from the State University of New York at Buffalo Law School. So we all welcome Justice Pitt to the bench, to the First Department. Thank you. Thank you. And so with that, now I will call the calendar. I have a note here that we have 6 hours of oral argument requested, 6.5 hours of oral argument requested. So obviously that is far too much time. So I'll ask, please, only request the time that you actually need for argument. Please keep in mind that we have read your briefs. We are fully familiar with your arguments. If obviously, we have additional questions, based upon the time that has been allotted, we will certainly go forth and ask those questions. People versus Apertivo Conservalio. Excellent. Submitted. Mcrae versus New York Flower. How much time? Okay, 7 and 5. Julie versus Myron. Submitted. Gann versus the City of New York. Submitted. And for the record, Justice Gonzalez was recused on that matter. Sabakis versus Poyadidis. Do we have an opposition on that? No? Would you like to submit, counsel? 5 minutes. Thank you. Riggs versus Brooklyn Hospital. How much time? 12 and 2. And so you don't have opposition either. Would you? Oh. 10 minutes, please. Okay, so 8 and 2. And how much did you request? I'm sorry. 7. People v. Sandra Zalazny?
You skipped one. People.
Oh, I'm sorry, People v. Born Polidor. Oh, I'm sorry, how much time? 6 and 2 and 6. People v. Sandra Zalazny. My gosh. Submitted. Hammond versus Equinox Holdings. Let's see, 8 and 5 and 7, and I am recused on that matter. Silver Grove Advisors versus Crosswing Holdings. Submitted. Mercedes versus Dexter. Submitted. People v. Malachi. Submitted. Kikari versus Soto. Submitted. Excellent. AZ versus City University of New York. We were on a roll there. Sorry. 5 and 2 and 6. People v. Mark Morales. Submitted. Powers versus River Center. 7 and 2 and 5. People X-Rail Alan Farman versus Braun. Submitted. People v. Arthur Meredith. 4 and 1 and 3. People v. Rashad Brimage. Submitted. Empire Core versus Perennial Painting. Submitted. Farina versus Katzandanis. 5 and 2 and 5. Cayo versus Throgsnet Rehab. Submitted. First case up for argument is Mcrae versus New York Flour. Yeah, I know.
May it please the court. My name is Stephen Castles with Bavaro, Cotter, and Bender. We represent the defendant appellant, C&P Real Estate Holdings, LLC. This is a case where the plaintiff claims on February 22nd, 2014, he sustained a slip and fall injury due to what is claimed to be a dangerous accumulation of ice. What the record has shown and what this appeal is the subject of is that there has been no such demonstration of evidence in this record. And for that reason, we ask the court to reverse the lower court's ruling and to rule in favor of the defendant appellant for summary judgment. As a first point, the plaintiff in this record failed to identify any defect on the premises. And to make that finding, this court need look no further than the plaintiff's own testimony. His testimony in this 5 a.m. accident is that he...
I don't understand. The plaintiff identified an area that was icy as the source of this fall after he fell, did he not?
Counsel, plaintiff identified ice on the premises. That was an observation made after he had fallen.
Sorry, there was not.
Plaintiff identified the existence of ice after he had fallen. And that was an observation that he made, but at no point did he say that he actually slipped on ice or that ice was somehow involved in his accident.
I'm not understanding you, Counselor. The plaintiff testified that he slipped, fell, and immediately after identified the area that he had just slipped and fell on as there being ice. So
Well, he didn't identify that the area where he had slipped and fell was in fact ice. He did say after the fact that there was ice somewhere on the property, but at no point did he say that it caused his accident. And his testimony is...
Well, he described it as hard and the ice patch as larger than his foot.
Yes, and that was his description of the ice he did observe after the fact. At no point leading up to his fall or at the time of his fall did he see what he slipped on. And he made perfectly clear with his testimony that as he was walking, he was looking ahead of him, he was looking at where he was stepping, and at no point leading up to the point where he fell or at the time that he fell did he slip at all, did he see any ice?
Well, what about the meteorologist's reports showing that there had been multiple black ice warnings the day before the plaintiff's accident?
That's a very valid point. But to clarify, that advisory was issued starting at midnight of the morning of this 5 a.m. accident. So in other words, the advisory warning was issued at most 5 hours before the accident itself occurred.
Yes, counsel, but doesn't the record show that there was, isn't the record lacking an indication as to whether the ice or snow was ever cleared from that area? The testimony of Mr. Jakubowski was that he wasn't aware of whether there had been any clear. Oh, thanks. The testimony of Mr. Jakubowski was that, on behalf of the defendants, was that he wasn't aware of any cleaning or maintenance activities in that area for 3 weeks, and yet there's extensive documentation with respect to both meteorologists that there was snow, that there was a snow depth, that rain was above that there was rain. How do you arrive at your conclusion?
So that's a very good point.
Thank you, counsel.
So John Jakubowski was an eyewitness to the scene. He was called to the plaintiff while the plaintiff was still on the ground at the scene. He did show up at that time and observed no snow, no ice, or anything slippery in that area. John also testified that there was, in practice, general practices as to how they do.
Counsel, didn't Mr. Jakubowski testify that he didn't look for snow or precipitation when the plaintiff fell or anywhere on that ramp?
Well, I submit that he did say that he did not see any because he wasn't, there was none to be seen. This is a case where the plaintiff didn't see any snow or ice before his accident. John, the only other known witness to have been there at that time within moments of the accident, he too did not observe any snow or ice. While he may have not necessarily been looking or inspecting the sea after the fact whether there was ice, he also testified that he did not see any snow or ice.
This happened at 5 o'clock in the morning before the sun came out, right?
That's correct.
And the warning from the National Weather Service was that there was black ice, which is, by common understanding, ice that you don't see, right?
And that's exactly our argument, our secondary argument, which is, if anything, if there was any ice that existed on this property that morning, it was black ice. And black ice, as it is well settled and through common experiences, is difficult to see. It's undetectable to the naked eye. So there is a lack of constructive notice in this case because the plaintiff did not see this ice. The John, who showed up moments later, did not see this ice. This ice was undetectable. And as a result, there is a lack of the element that the plaintiff needs to prove, which is that this dangerous condition was visible and apparent. And here, it was black ice, which was not.
Thank you, counsel. You have time on rebuttal.
Thank you.
May it please the court, John Lavelle on behalf of respondent Orrin Mcrae. It's our contention that the motion was properly denied at the trial court level, that the defendant was unable to meet their burden of proof because they were not able to point to the last time they'd inspected and or cleaned the area where the plaintiff fell.
Well, what about your adversary's argument that Jakubowski, who came immediately or soon thereafter, did not see any any ice in the area.
The argument is inaccurate, Your Honor. On page 295 of the record, Mr. Jakubowski is asked whether he saw any ice, and he's asked whether he looked, and his answer is no, he did not. So, yes, he did not see the ice, but he did not see the ice, and he did not look for it. So he's not able to say whether there was ice in that location or not.
Counsel, what about your adversary's assertion that your client never said ever anywhere in any context that he slipped on ice?
That's not true, Your Honor. Page 161 of the record, question is asked to Mr. Mcrae, and how do you know it was ice? Answer, after I land on the ice, I can see it on the ground. My client clearly testified that he fell, he slipped, he saw the ice when he arrived on the ground.
And let me ask you as a follow-up, do you think there's any import to the fact that he didn't see the ice until after he slipped on it? Is there any legal significance to that?
I do not believe so, Your Honor, because, I mean, the argument would be if he saw the ice, you shouldn't have slipped on it. It's one of those traps that plaintiffs tend to fall into. And the fact that he didn't see it, if you go line by line through the testimony, he was going down a ramp looking ahead. He did not testify that he was looking at his feet. And if in a situation where he fell and just couldn't figure it out, that might be a different situation, but that's not what we have here.
Counsel, what about this issue of constructive notice in terms of the cleaning schedule or lack thereof, if it at all?
So at the time that the accident happened, there was a Mr. Baum who was responsible for maintenance of the parking lot. He was not present on the date of the accident. Mr. Jakubowicz could only testify about general customs and practices. As the case law makes clear, that's not enough. They have to point to the last time the inspector came through the area. And even if they satisfied their initial burden, my expert pointed to snow accumulations dating back to February 3rd, 19 days before the accident. He testified about the temperature variations over that time and the presence of ongoing ice. And he also mentioned that at 6:45 p.m., not midnight, the day before, there was that issue, the warning issued by the National Weather Service for the formation of ice, which obviously would have given the defendants plenty of time to go out and inspect and or pre-treat or treat the area, which cases would have been avoided. Thank you.
Thank you, Counsel. Counsel, you have, I think, 2 minutes on rebuttal. Is that correct? Yeah.
Thank you. Now, to dispel any notion that the plaintiff identified a defect on this premises, his testimony is overwhelmingly clear that he did not establish that defect. The question asked for him, did you see any snow any place? I don't remember. Did you see any ice? I don't remember that. And before you slipped and fell, did you at any time see any ice? No. At any time, did you see any snow? No. Were you looking where you were going to be stepping? Yes. This is someone who fell, unfortunately, that day for some reason other than snow and ice. And that is the claim that's being made against my client as the premises owner. And for that reason, since there is no evidence of accumulation of snow and ice, my client should have received summary judgment. Now, I do concede that there is no specific mention in the record as to the last time an inspection had physically been performed before the accident. I submit that there was ample evidence to substitute otherwise. That evidence is sworn testimony by both the plaintiff and John Jakubowski, who were there at the scene, who both testified in unison that there was no snow or no ice that either of them saw.
Actually, thank you, Counsel.
Thank you.
Slabakis versus Polydesis.
May it please the court, my name is Mario Biaggi. Thank you for your welcoming comments, and it's nice to be back in person. I represent the plaintiff, and I'd like to address the issue of the release first, and if time permitting, its alleged status as a broker. Our position with respect to the release is that there's no evidence in this record that suggests, or certainly establishes irrefutably that the relissees, Platinum, are affiliates of these defendants, and as such, they should not be afforded the protection of that release. I think the court below got it right the first time in the motion to dismiss, when it said that there was no such evidence, and then we had a second motion, and no additional evidence was presented. But what the court did to turn it around improperly, and I think that's the error, is they based the reversal on allegations in the plaintiff's complaint, specifically paragraphs 7, 11, and 14, for the proposition that there was an affiliate relationship. But if the court, I'm sure, has read those paragraphs, there was nothing in there that would suggest that. The only reference to Platinum was that a judgment had been assigned to Platinum. And interestingly, when we presented that paperwork and argument to the defendants, they didn't cite to this court any evidence of any affiliation in their records. They certainly had the opportunity at the lower court to present shareholder certificates or whatever other evidence they would have with respect to affiliation. They, too, attempted to turn the complaint and pleadings in the complaint against the plaintiff and the allegations. They relied on a different paragraph, 2 words specifically that it was stated Bovadis' company, Platinum, and then they went on and drew every possible inference in favor of the defendant, rather than, as the law requires, the inferences should be in favor of the plaintiff. So they couldn't have concluded.
Counsel, I have a question.
Sure.
So to the extent that the release was signed on July 31st of 2018,
I'm sorry, say that, I didn't hear it.
sorry, to the extent that the release was signed on July 31st, 2018, and the closing was the next day, August 1st, of what import is the release itself? Did it have a finite term? Because it does say in pertinent part that the release lasted from the beginning of the world to the date of this mutual general release.
Well, that was our position in the papers. I didn't address it in oral argument, but I think that there's a cutoff point as of that date. I would direct the court's attention to similar language in the Wild versus Finger Lakes Association that is parallel to this situation here, almost identical, where they they denied the release as protection for those defendants, and there was proof of affiliation in that case. Here, there's no proof of affiliation. And in that case, they determined in a situation where there's an unidentified claim and an unidentified relessee, in this case, these defendants, the court's not in a position to kind of guess what this is all about. There should be extrinsic evidence to prove it. It wasn't presented. And in that regard, there should be some discovery with respect to this issue, and that's why we believe that the release itself didn't protect the defendants. May I turn to the brokerage very quickly?
I think we're good, counsel. Thank you.
Thank you for your time. Nice to be back.
Take care. Riggs versus Brooklyn Hospital. You ready?
Yes, Your Honor. May it please the court, my name is Ken Sutak. I represent the appellant, and I thank the court for permission to having filed an oversized brief. I know it covers a lot of issues. I would like to just focus on the 2 most important: the plaintiff's duty of duty of investigation, if any, and the defendant's duty to make full disclosure of all material facts, if any. The duty of investigation, it applies to 3 categories of fraud plaintiffs, as I pointed out in the brief: sophisticated parties, legally sophisticated parties, parties represented by attorneys, or at the very least advised to consult attorneys by the defendant, and that embraces even comparatively inexperienced business people who are nevertheless represented. And then parties who were, quote, fully knowledgeable and apprised in advance of the matters as to which the deceitful representations are claimed.
Maybe we could get to a more basic thing. On what basis does your client have any right to these funds?
I'm sorry, I didn't hear the last.
On what basis does your client have a right to the funds?
A right to what, Your Honor?
To the funds, the money.
Well, my client had,
Your client's the doctor, right? Dr. Riggs?
that is correct.
And your client didn't pay any of the premiums, is that correct?
Well, my client had a contract, an
Did your
employment.
client pay any of the premiums?
He did not pay the premiums.
Did he pay anything else? Did he
To-
pay any money
To
whatsoever?
MLMIC? No.
So on what basis is he claiming the refunds, the money back?
He's entitled by the terms of the plan and by the New York insurance law to receive that cash consideration.
So he doesn't expend any monies whatsoever. He doesn't pay for the policy. He doesn't pay for the premiums, and yet he is entitled to some type of refund? What is he being refunded for? What monies did he expend that he would be refunded for?
Well, two things, Your Honor. It has been construed in a situation where there's an employment agreement where.
So for what monies did he expend would he be entitled to be refunded for?
He's not being refunded. Nobody is being refunded. Neither BHC.
He hasn't
nor
put
he.
out any money, so why would he be entitled to receive any monies in return?
Well, when you say he hasn't put out any money, the premiums were deducted from his incentive compensation as part of his employment agreement.
Oh, so Justice Mazzarelli asked that question. She asked whether or not he had expended any monies towards the premiums for the policy. You said no. So now your argument is that although he didn't actually pay out any money, that the monies for the premium were deducted from his salary or from his.
That is correct. He did not pay the premiums, but the hospital had the contractual obligation to pay the premiums, and then they had the contractual right to deduct the premiums that they paid from his contractual incentive compensation.
So he lost compensation because the monies were being paid for the premium?
Well, that is correct, and that is the holding of the Columbia Memorial Hospital case, which is one of those cases. That's a third department case, which is now on appeal to the.
Did they actually deduct it, or did they just have the right to do it?
They had the right to do it.
Did they actually deduct it?
I am sure that they did, but we.
Well, you
have
say
not
you're
had
sure
discuss-
that they did. Is there anything in the record to support you're sure that they did?
Well, there would be a reasonable inference which must be implied.
Did they or didn't they?
I'm sorry?
Did they deduct it, or did they not deduct it?
Only discovery will show how much they deducted, but they had to have deducted something by the terms of the contract. How much, we won't know until we take discovery.
Counsel, but doesn't your client have payroll stubs?
Does he have what?
Payroll stubs. When he got paid, doesn't he know what the deductions on his check were for?
Invoices were sent to the client, okay? Then passed
the
on to the
premiums?
payment department of the hospital.
Counsel, invoices were sent for the premiums,
That is correct.
indicating that there were deductions?
No, the invoices would not indicate that there were deductions.
So on my payroll stub, it says X amount of money for health insurance, right? So did he receive something like that where on his payroll stub it'll say X amount of money for life insurance or X amount of money for medical insurance?
That documentation would have to be obtained in discovery. We're on a motion. to
No,
dismiss.
I have my payroll stub. Does he not have a payroll stub that documents this?
I don't believe he has payroll stubs at this point in time. This all took place many years ago, Your Honor. The agreements were signed in 2012. He left the hospital in 2016.
So he would not still have his stubs. He would not have any documentation whatsoever, even a recollection that his payroll stub or invoice that he received showed a deduction for health insurance or for the malpractice insurance.
They must exist, but whether they are in the possession of the hospital or the department that he worked in, or by the luck of the gods, he would have copies himself, I can't tell you at this juncture without discovery.
I'm a little confused now, even more confused.
little?
I'm even more confused, because you said that the hospital had a right to deduct it from his incentive pay.
That is correct.
Now, was he ever paid incentive pay?
I don't believe he ever received a cent of incentive pay because of the deductions, but how much the deductions were, I cannot tell you without discovery. I do know that he has informed me he never received a cent of the incentive compensation.
I'm confused about why he would get incentive pay. He's working in a hospital. What, you get paid extra if you operate on more people? I mean...
No, in a sense, yes. That is the structure of his employment agreement. And there are several cases which hold that the terms of the employment agreement control in this situation with respect to who gets the money.
And
That's one of
does
the cases
employment
that's on appeal
agreement
to the
say-
Court of Appeals right now.
Counsel, does the employment agreement say that to the extent that premiums are paid by the hospital, that money will be deducted from the employee's incentive or paycheck or anything else?
Yes, I have pointed out the provisions of the contract in the brief.
But you
and-
don't know that it happened. You're speculating that it may have happened.
Well, I am deducing that it happened, and certainly there's a reasonable inference that it happened because he did not receive any compensation beyond his base compensation because the premiums on the liability insurance would have been deducted pursuant to the right of the hospital from that incentive compensation.
So, counsel, is it your position that, say, if the hospital only deducted 1% of the premiums, that the hospital would be entitled to 99% of the proceeds of the demutualization, and he would be entitled to 1%? Is that how you're breaking this up?
Not at all, Your Honor. The confusion over premiums runs through a number of cases.
No, we're not confused about premiums.
The premiums have nothing to do
Well,
with who gets
okay,
the money.
Let's just agree to disagree about that. Let's say the hospital owns the policy and the hospital pays the premiums because it's in the hospital's interest for your doctor to have malpractice insurance. In that case, you're saying even in that case, once there's a demutualization because your doctor is the one covered under that policy, that your doctor or your client is entitled to the proceeds of the demutualization?
That's actually a fact situation which itself is on appeal because you said, let's say the
I agree,
hospital
we
owns
all
the
agree.
policy.
I'm just asking you, is that your position? Because we're all
No, it
kind
is
of
not.
confused about what your position
It cannot
is.
be because the hospital did not own the policy. Riggs purchased the policy on his own, as he was required to do. He had to pick his own insurer. The hospital had no control over that whatsoever except an approval function. The insurance policy identified him as the policyholder, identified him as the insured, identified him as the policy administrator.
But the hospital's the one paying the premiums.
Hospital is the one paying the premiums because the hospital is going to deduct those premiums from his compensation. He wasn't making all that much money for an esteemed surgeon in his field.
Actually,
based on
Counselor,
base
I'm
salary.
sorry, your time is up. I stopped it because Judge Scarpula had a question. Sorry.
Thank you, Your
We
Honor.
have your
Do I
adversary.
still have rebuttal time?
Yes, definitely.
Good afternoon, Your Honors. May it please the court. Matthew Schenker for the respondent, the Brooklyn Hospital Center. Your Honor, just to clarify the record, page 172 of the record talks about incentive compensation. It's not how my adversary describes.
Page 172 what?
172 of the record
Right, keep
talks about incentive compensation. It's paragraph 6.
Thank you.
So, Counsel, can you clear up, were any monies deducted from his incentive compensation for purposes of payment of the premiums?
There's nothing in the record, Your Honor, but there's nothing in the record one way or the other, but the provision is not how my adversary describes it. Incentive comp is only paid out if the revenue generated by the doctor exceeds the expenses. And one of the expenses is malpractice costs. So there's no allegation that the doctor ever qualified in the first place for incentive comp because he met the threshold of revenues exceeding expenses.
But your adversary argues that we don't know and the record cannot be fully fleshed out at this point because there has not been any discovery. So we would not know without discovery as to whether or not he met that threshold or did not meet the threshold, and so therefore whether any monies were in fact taken out or were due to be taken out.
I have three responses to that, Your Honor. The first is that it's the doctor's complaint. The doctor's complaint was dismissed on a 3211 motion. There's no allegation in the complaint that he's owed these monies as a result of incentive comp that he otherwise would have been paid. The second point is this court's decision in Schaefer does not speak to incentive comp at all. It talks about two things: who paid for the policy and whether or not there was an agreement about who would receive the proceeds of a demutualization. And this court found in those circumstances where the employer paid and it was not negotiated, the employer receives the funds flowing from the demutualization. But I don't want to lose the forest for the trees, Your Honors, because beyond who's entitled to the monies under the Schaefer rubric, and I understand that this court has two cases and this issue is going up to the Court of Appeals, you don't need to get there. There's no fraud. Asking someone to sign an agreement is not fraud. Asking someone for an acknowledgement that money is owed to the hospital is not fraud. This is a doctor who had left his employment 3 years prior when he was being asked to sign the assignment. There's no duress. There's no imbalance of power. He was asked by someone at the hospital, "Hi, Dr. Riggs, will you please sign this assignment agreement?" And 7 days later, he signed it. So the court does not need to get to the issue of under the insurance law versus unjust enrichment, who's entitled to these funds. He assigned them away voluntarily, and every piece of paper that he points to in the record regarding alleged misstatements, there are none. An acknowledgement that someone else is owed funds is not fraud. Request to sign a document is not fraud. There's nothing in the record that suggests any misstatement of fact anywhere, let alone justifiable reliance, where he was informed of the nature of the transaction. He was told in the assignment agreement itself, there's a conversion from Milmick, there are these monies that may otherwise go to you, please assign them to us. And he signed it. We don't even need to get to the question of fraud, to the question of...
Counsel,
yes.
I'd like to just very briefly address the issue of unjust enrichment.
Yes, Your Honor.
So the cash payment that was going to emanate from the demutualization of the insurance company had a calculation of 1.9 times the total premiums paid, right?
Yes, during a 3-year period.
Over a 3-year period. So assuming that the policy was selected by the plaintiff doctor and the policy was paid by the defendant's hospital, which is what happened here, then to the extent that money was, for example, repaid as to the premium, what about the balance of the money, the difference between, I guess it would be the 0.9%. How do you argue that that 0.9% would fall in the hands of the hospital if the plaintiff chose the policy?
Sure. So the first issue, Your Honor, is we would argue he assigned it away. He signed the assignment agreement. But I understand your question to be, assuming he hadn't signed a contract giving it to the hospital, how do we get there? And we get there because of Schaefer and the fact that only one party contributed any equity to this company. And that party was the employer, in this case, the hospital. So yes, the employer's getting 1.9 times of what it put in, but Dr. Riggs paid 0. So based on this court's holding in Schaefer, if one party is going to get the benefits of that, it should be the party that expended something in order to provide equity to the company demutualizing. Thank you, Your Honors.
If I may, before I just run back to the unjust enrichment thing, I just want to emphasize one case that's cited in the briefs, It's Consulik, that's a Koncelik, v. Abadi. It's from the 3rd Department. It effectively answers the point that was made by my adversary with respect to, well, he was requested to do this. There was no, there was no misrepresentation, things of this nature. Well, there were certainly misrepresentations, but what Consulik says is that if you have a situation, and this is a rescission of an assignment case, if you have a situation where there is a request to sign the assignment form under circumstances of purported urgency, and even if there are no misrepresentations, but there are omissions of material facts, there is a confidential relationship created which gives rise to a duty of full disclosure of all material facts, and that is sufficient to bar a motion for summary judgment. That case goes to trial. So this business about the request, it's not exonerative. If anything, it's implicative. With respect to the unjust enrichment claim, I realize where it comes from. It's coming from Schaefer. Schaefer is still good law in this department. It's effectively on appeal through 3 of the cases that are before the Court of Appeals right now. But most importantly, this case is very distinguishable from the Schaefer facts. All of the Schaefer facts that were submitted to the Court of this court in Schaefer are in this record. And a comparison of those facts with a comparison of the Riggs facts shows that Riggs is eminently distinguishable, in particular because he had an employment agreement which provided that the premiums which the employer was obligated to pay would be deducted from his compensation, whether it's the compensation package or incentive compensation, doesn't matter.
Counsel,
That's
did
the
you
Columbia
plead-
Memorial case in
Counsel,
the 3rd Department.
Did you
Yes, ma'am.
plead that you paid the premium?
Say that again, please.
Did you plead that you paid any of the premium costs?
He did not pay any of the premium costs.
Oh, he did? Okay, wait a minute. Now we're back.
But here
Judge
again,
Nasral's
premiums,
original question
premium,
15 minutes ago. So my question to you is, you're saying that this is different from Schaefer, and I'm asking you, did you plead in your complaint, I paid the premiums on this policy?
that he paid the premiums?
Yes, your client. Did your client plead in his complaint that he paid the premiums?
Well, we can't plead that he paid the premiums because
Why
the hospital...
couldn't you plead that? Is it
Because we did plead all the provisions of the contract which provided for the premiums being applied against his compensation and deducted.
so?
He
Essentially, you
effectively-
did not plead that you paid a penny in premiums.
No, we cannot
Okay.
plead that he made a direct payment of the premiums. He did not do that.
Or an indirect.
Thank you very much, Counselor.
Thank the court.
People v. Bourne Polidor.
Good afternoon, Your Honors. May it please the Court, Rachel Pecker of the Legal Aid Society on behalf of Mr. Bourne Polidor. Here, Your Honors, the jury may have convicted Mr. Polidor under one of 2 illegal theories. First, the jury may have been persuaded that Mr. Polidor had the propensity to commit these acts because of highly prejudicial prior burglaries, and/or the jury may have been convinced that he only needed to have the intent to steal at the time he stole and not at the time that he entered the apartments. Either way, this court cannot be sure that the jury convicted him on a legal basis. The mid-trial modification of the court's Sandoval ruling was error. Mr. Polidor did not misrepresent that he had never been convicted of a crime or that he was a novice. If the court wanted to clarify the record to make sure that the jury knew that he had more than 1 misdemeanor and 4 felony convictions, it easily could have done so by crafting a more narrow remedy and clarifying the ambiguity by less
So
prejudicial.
the court told the defendant, I believe at least 3 times, possibly 2 times, that depending upon his testimony concerning the Sandoval ruling as well as the Molyneux ruling, that he may, quote unquote, open the door, and therefore the court would have to modify or change its ruling. The court also said to the defendant, if you tell me, I'll preview now what's going to open the door. So if there's an offer of proof, or tell me exactly what you're going to say or what your testimony is going to be, I'll tell you now. I'll give you a heads up as to whether that's going to open the door or not. And he declined.
Correct, Your Honor, sorry, echo. It doesn't matter that the judge warned him here because the judge and all the parties knew that he was going to challenge intent. In fact, by the second and third Molyneux application, the prosecutor made five.
I don't understand, counsel. The warnings from the court, I believe there were more than that. I believe there were 4. So warnings from the court don't carry any weight in this analysis?
Of course they do, Your Honor. But here the judge gave a warning that if he opened the door, but at that point, the judge and the prosecution felt full well that if he took the stand, he'd be challenging intent. And starting at the second Molyneux renewal application, the prosecutor said, if he were to take the stand, the only possible thing he could testify to was an innocent alternative explanation. So then Mr. Polidor took the stand, and he did just that. So nothing had changed except that the court was worn down by the prosecutor's badgering. Nothing had changed. Mr. Polidor testified exactly as the parties understood that he would. And in fact, the court got it right the first, second, third, and fourth times, that although these prior burglaries were relevant, they were vastly, extraordinarily prejudicial. The court ruled all along that they were too prejudicial, despite their relevance. And in fact, the respondents—
Back to what I just asked you. So the warnings make no difference. They have no bearing here. The defendant took the stand at his peril. He ignored the warnings, and he testified the way that he wanted to, ignoring what the court said. That makes no difference?
I think that the judge gave a warning, but nothing in Mr. Polidor's testimony triggered the judge acting on that warning because he testified exactly according to what the parties understood. If he testified, he would challenge intent by an alternative innocent explanation. That's on the record, throughout the record, that that's what they understood. And then he did just that. And in
How
fact—
could it be that he testified to exactly what the parties understood he was going to testify to when the court specifically asked for a proffer of proof as to exactly what the testimony was going to be, and he declined?
Our Sandoval and Molyneux case law, Your Honor, respectfully, doesn't require the defense to give a proffer to put the prosecution on notice.
No, it does not. I totally agree with you, and I think that the court was being, somewhat solicitous and understanding of the defendant's rights to help the defendant gauge his testimony so that he did not, in fact, open the door.
Your Honor—
To additional questioning by the prosecution.
Your Honor, even if that's the way the court rules, the court's mid-trial modification was error because of the quantum of evidence that he allowed in. He allowed 3 prior burglaries from 9, 10, and 12 years earlier.
Because the defendant testified he had gotten into trouble, I think he said plenty of times, or he had plenty of arrests, something to that nature.
Correct.
So, would you not want to quantify that?
Well, that goes back to the Sandoval point, Your Honor, which is that—
asked about his criminal history, he admitted that he had been in trouble with the law plenty of times. He admitted his convictions in 2003, 5, 6, 7, and 12, and admitted that he had pled guilty to all of the felonies he was convicted of.
And unlike other cases where a modification has been upheld by this court, he didn't say he had no convictions, and he didn't say that he was a novice or deny anything. And it was actually, he was answering correctly the defense counsel's question. So if the court wanted to clarify that he had more than that, they could have done so by allowing just that instead of 3 prior burglaries.
But he led the jury to believe that he had only been convicted in 2002, 3, in those years, 2003, 2005, 2006, 2007, and 2012, where in fact, he had been convicted in other years as well.
But the judge, and if the judge was concerned about that, it could have offered a more narrow remedy. Prosecution, you may cross him. Does he have other crimes? Yes. Do you have convictions in X, Y, Z? Instead, the judge let them go into 3 prior burglaries and a highly prejudicial statement that although the defense attorney may not have noticed to it, had the prosecution raised the statement at its first, second, third, or fourth Molyneux application, the defense attorney very well may have advised his client differently regarding the risks.
Well, that's pure speculation. And also, did the court not give a limiting instruction to the jury as well?
Yes, Your Honor.
Concerning those prior convictions?
Yes, Your Honor. But
So why would that not be adequate under the circumstances?
I think under these circumstances, the limiting instruction wasn't adequate because the probative value here has to outweigh the prejudice, and it merely didn't. In fact, the respondent's first point of their brief proves our point about probativeness and prejudice. They argue that it was overwhelmingly inescapable that he had the intent to commit these crimes. If that's true, then the prior burglaries could only go to propensity, and they had no probative value and were only highly prejudicial. I see my time is up. Thank you.
Thank you.
May it please the court, Amanda Regan on behalf of the people. After defendant ignored the court's repeated warnings that the pretrial rulings may be revisited, and after he declined the court's invitation to make an offer of proof and receive a specific advanced ruling as to whether his proposed testimony would open the door further, defendant offered game-changing testimony during which, for the first time, he offered several innocent explanations for his presence inside the apartments that were burglarized. And in light of this testimony, the court properly modified its earlier rulings to permit the people to elicit the fact that 3 of defendant's prior convictions were for burglary. The court, however, did not allow the people to go into the underlying facts of those 3 prior convictions, and the court allowed the people to use the 2006 statement to the police.
Well, by specifically allowing the people to question the defendant concerning prior burglaries, given the fact that this was a burglary, why would that not lead to some question as to propensity as opposed to a probative value as to intent?
Your Honor, here the defendant placed his intent directly at issue by offering these innocent explanations, and the people were permitted to offer evidence to rebut those innocent explanations, and were permitted to permitted to offer evidence to rebut those innocent explanations. And here, challenging the people's ability to prove intent, which was the defense position from opening statement, is very different than affirmatively offering numerous innocent explanations as to why you were present in a location burglarized.
Counsel, when a defendant takes a stand, presumably it is to offer an explanation as to whatever conduct is being alleged. How does anyone take the stand if anything that they've done in the past can be used against them? Like, how do you balance that out if it's not for propensity at all?
Well, here, the defendant was given the explicit opportunity to preview his testimony for the court so that the court could...
Does he have to do that?
He does not have to do it, but the court was giving him the option to preview his testimony so that he could be told explicitly, yes, I'm going to now, if you testify to this, yes, I will allow this rebuttal evidence or this evidence in, or no, I will not allow this evidence in. And defendant declined that opportunity, and the court warned the defendant several times throughout the trial that depending on what he says, the court can revisit this ruling and reopen it. And courts have routinely allowed this sort of prior crimes evidence in situations that are virtually identical to the situation here, where in a burglary case, a defendant offers an innocent explanation as to his presence inside the location burglarized. This sort of evidence is routinely admitted.
Was the limiting instruction given by the court sufficient?
Yes, it was, Your Honor. The court actually gave 2 limiting instructions, the first one coming during cross-examination immediately after the prosecutor elicited this information, and then again during its final charge, the court gave another limiting instruction warning that the jury that this evidence can't be used for propensity, and it is only to be used to determine the defendant's intent at the time that he committed the burglaries, and also to to judge his credibility. And here, the defendant's prior crime evidence was highly probative because it made it much less likely that his instant conduct was innocently done. And there's several cases that we cite to that support that proposition. You know, and as the court has noted, any prejudice to the defendant was minimized by the limiting instructions given by the court. And just briefly, to address Rodriguez, you know, we cite that case for the proposition that when the defendant offers an innocent explanation in a burglary case for his presence inside the location burglarized, that this sort of prior crimes evidence is admissible. In Rodriguez, this court held that the quantum of evidence was improper, that the court allowed. Here, this case is so easily distinguishable. We have, in Rodriguez, the people were permitted to bring in 3 additional witnesses, introduce photographs, video even of the prior burglary. Here, all we were able to elicit was the fact that 3 of defendant's prior crimes were burglary, just plain and simple burglary, and this 2006 statement, which defendant essentially said, yeah, that's my handwriting, yeah, that's my signature on the bottom. I don't remember making that statement. I don't remember talking to the police. And once defendant said that, the prosecutor pushed no further. And there are other issues raised in our briefs, but unless your honors have any other questions, we ask that you affirm.
Thank you.
And I'd like to, your honors, I'd like to address a few quick points. It was said by respondent that once Mr. Polidor took the stand, the modification was warranted because his testimony was incredible. I don't think it was actually that incredible here. In fact, the jury acquitted him of the 3rd count, robbery in the 3rd degree, and found him guilty of the lesser, petit larceny, showing that they actually did credit his testimony to some extent. And that's because his 730 history, his psychiatric history, his substance abuse and use, including on the day in question, the time that he spent in the apartments, and the delusional state that the police found him in, they all corroborate that his testimony was completely plausible. Even if another individual with different proclivities, it would be incredible. It was not incredible for him. And thus, without the priors, even with a limiting instruction, the jury may have believed his testimony to acquit him of the higher Rob 3 and convict him of the criminal trespass. Instead, the jury ended up asking about intent in a jury note, and the court also erred by failing to give one additional clarifying sentence to the CJI charge about intent on the only issue to ensure that the jury understood when he had to have intent. Finally, your honors, in addition to those 2 errors, which were not harmless, his sentence was wildly excessive. He could have gotten sentenced to 7 years. His last offer from the court pre-trial was 10 years. And then after exercising his right to go to trial and to testify on his own behalf, his sentence was 50% more than the last offer, or 15 years, the maximum. He has predominantly nonviolent theft offense, which are consistent with his characteristics. Given his profile, I ask that this court find that his sentence was also excessive, in addition to finding that the Molyneux and Sandoval errors, as well as the CJI charge, warrant reversal.
Thank
Your
you.
honors have no further questions. Thank you.
Hammond versus Equinox Holdings. I'm recused on this matter. Can you get it? Oh, don't disconnect it.
I will try not to. Go ahead, please.
May it please the court. Good afternoon, Your Honors. Matthew Grasso from Held & Hines, representing Michael Alexander, the defendant appellant. This appeal concerns the October 26, 2020 decision and order of the Supreme Court in New York County, which entered default against Mr. Alexander on re-argument after initially denying a default on the exact same evidence. As we will demonstrate and has been demonstrated in our brief, the lower court erred in its decision to grant a default in several respects. First, there never was and still has not been any service upon Mr. Alexander of the summons and complaint in this matter. There's no notice of appearance ever filed by counsel for Alexander, and consent to e-filing on NICEF cannot serve as a
What
notice of
section
appearance.
of the CPLR did you move under to enter a default judgment?
I'm sorry, Your Honor?
What section of the CPLR did you move under?
We did not move, Your Honor. Respondent moved for a default against us. And
I'm sorry, I was thinking it was.
the original order of the court from sometime, I believe, in
Right.
April denied a default,
Right.
and then respondents
They
moved.
moved under a particular section of the CPLR that required a affidavit of service, correct?
I'm sorry?
They moved under a particular section of the CPLR which required the production of an affidavit of service.
Correct, Your Honor.
Thank you.
And what is before the lower court, it was part of the record, and it's docket 45, I believe, in the lower court, is an affidavit, but not an affidavit of service. It's an affidavit of counsel stating and basically adjudicating from their office that they believe that there was an appearance made that should be the
Well,
equivalent of.
you made a motion in response to something, right? You
Yes,
made
in
a motion
opposition.
To consolidate the two proceedings. There was a proceeding in Brooklyn.
That was a motion to change venue that did also seek consolidation, but the court did not rely upon that in their decision. The court solely relied upon that there was a notice of appearance allegedly filed in this matter, which we contest there was not.
So one important question, counsel.
Yes, Your Honor.
When you moved to change venue and to consolidate, was the appearance a limited appearance or was it a general appearance?
It's our position that it was a limited appearance.
Did you say so? Did you indicate in any way to the court? And if not, what do you rely on to establish that it was a limited appearance that did not confer jurisdiction over the person?
Two things, Your Honor. The first is that it was made pursuant to a 511B demand being rejected.
Say again?
I apologize. The motion was made pursuant to a 511B demand being rejected. And second, the court in its order where they found that there was a notice of appearance filed explicitly stated that the date was May 23rd, which was not the date of that motion. The only possible reliance for that date could have been that they were deeming appellant's counsel's consent to e-filing on NICEF as a notice of appearance. And as we stated in our brief, the court in Obstfeld versus Thermo-Niton Analyzers LLC stated explicitly the Uniform Rules for Trial Courts 22 NYCRR 202.5-B, sub B, sub 2, sub Roman numeral 2, provides the filing of a consent to e-file hereunder shall not constitute an appearance in the action, and further went on to hold that it merely preserves jurisdictional defenses, such as a 511B demand, that may be available to a litigant whose counsel agrees to electronic filing. This is distinctly different from the similar NYCRR provision that respondents rely on in their brief, which is 22 NYCRR 202.5-B sub F sub 2, sub Roman numeral 2, which only applies to interlocutory documents. The summons and complaint is not an interlocutory document. It is an initiatory document. So service could not have possibly been affected under that manner. And since Obstfeld and the Uniform Rules for Courts deem that, an attorney consenting to e-file on NICEF cannot be deemed an appearance in the action, and the court could have only possibly relied upon that for the May 23rd date in the order, there was no notice of appearance filed, so to state so was error by the lower court. Even if, however, this court deems that the lower court was correct and that was an appearance, any default that did exist was waived by the stipulation, which contained a conditional waiver. The language of the stipulation explicitly states, "It is hereby stipulated and agreed by and between the parties, defendant shall respond to plaintiff's summons and complaint within 45 days of the stipulation." The stipulation was entered into after the original order that denied the default. The plaintiff timely complied, moving to dismiss within those 45 days, so therefore any default that could have possibly existed, which you contest did not, would have anyway been cured by our compliance with the conditional waiver.
So, counsel, what you seek is time to file an answer?
Well, we seek to vacate the default. We filed a motion to dismiss, which was also denied in the same decision and order of October 26th, but it was notably denied only as moot due to the decision to overturn it itself in the lower court. and enter the default. It was not denied on any meritorious standard. So what we seek is to have the default vacated, and at that time, we would either file an answer or revive our motion to dismiss, depending upon whatever the court's directive is. But first, we need to vacate the default, and that is what we seek at this time.
Counsel, the stipulation that you mentioned, did it preserve any rights for the plaintiff in terms of appealing the first order?
It preserved the right to appeal. It did not preserve the right to renew and re-argue. And even if that is read into the order by this court, it still would have been filed late. The notice of appearance was filed, the notice of entry on that order was filed almost 60 days prior to the respondents moving for renewal and re-argument. What they did was the respondents filed a second notice of entry approximately 28-ish days after the first one filed by co-defendant Equinox, and then moved within 30 days of that. And there's no provision in the CPLR, and there's no case that I'm aware of that permits a party to file a second separate notice of entry to essentially restart the clock on their time to move for a motion to renew and re-argue, which is the motion that this decision and order was based on. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court, Ethan Leonard, the law offices of Neil Brickman, for the respondent, Stephen Hammond. This is ultimately an action for per se defamation, but the issue before this Court is a very simple one. CPLR Section 320 governs here. The statute is clear on the supporting case law throughout our briefs, is fundamentally unopposed and unassailable. Under 302B, an appearance of the defendant is equivalent to personal service of the summons upon him. In this case, no jurisdictional defenses were timely raised. There's a lot of question here about jurisdiction versus venue. What appellant is arguing is essentially venue questions, not jurisdictional questions. It's undisputable that Alexander appeared by counsel on May 23rd through a demand to change venue. It wasn't just simply, we accept NISIS. It was a demand to change venue. Then on 6/7,
So
less than
Counsel,
two...
you're saying that the e-filing by your adversaries, by the defendant's counsel, obviated the requirement that you provide proof of service of the summons and complaint?
What I'm saying, Your Honor,
in order to get a default judgment?
Essentially, ultimately, yes. What I'm saying, Your Honor, is that Section 320 of the CPLR says that an appearance by counsel has the same effect as service of the summons and complaint. In this matter, we did submit an affidavit of service which reflected and denoted Section 320 as the basis for service in this matter.
So counsel, how do you square that with 306 service?
Your Honor, I didn't unfortunately write the CPLR, but...
Right, but I mean, that doesn't square with service, that service is accomplished by this, and this. It may be that a notice of appearance might give one an equivalence, but particularly if you're seeking a default judgment against another person, we've got to construe 3215 very, very strictly, and that says you need to show service of a summons and complaint, not the equivalent, not something like it, not I filed with NISIF, but service. And we both agree you didn't serve the summons and complaint.
But for Section...
I'm just asking, do we both agree that you didn't serve the summons and complaint?
But for Section 302, absolutely, Your Honor.
Okay. So here's my second question. They definitely wanted to litigate. You knew it. They knew it, right? No one disputes that they're here and they want to litigate. It's not like they left this alone for a year and a half. Why would we enter a default judgment under those circumstances?
Your Honor, there are a couple of reasons. One is that the court specifically, and there are two issues here. One is that there was an initial decision by this court, but the lower court, sorry, on April 24th, which specifically held that Alexander has waived any objections to service by appearing in this action.
Counsel, I can't understand you. I'm sorry.
Sorry. Alexander has waived any objections to service by appearing in this action and filing a motion to consolidate. That determination was never appealed by Alexander. It was never sought to be re-argued by Alexander. It was never questioned by Alexander. And that's the law of this case. There's no question before this court concerning jurisdiction or the application of 302.
We're talking about the 3215. You know, as do they, that they want to litigate this case. Clearly, you have to know this. So why would you seek a default judgment in a circumstance where, one, you yourself granted a stipulation to adjourn or to extend, and two, they filed a motion? You know they want to litigate this. This is not a case where someone's disappeared for months or years and whatever. Why are you pursuing a default under those circumstances?
Your Honor, if I may, the motions before the lower court had many aspects of it. One aspect of our motion was for a default because there was no answer at the time. Appellant had not appeared for a pre-motion conference, for a preliminary conference.
No, but they
did not
moved to
appear
change
for a compliance
venue, right?
conference.
They moved to change venue by that time, correct?
They did that immediately, yes.
They hadn't disappeared. They moved to change venue. You entered a stipulation with them. And then even after all that, you moved to re-argue. That's what I can't figure out. Why not just accept? They're here, they want to litigate, and accept the answer. Why move to re-argue a default in those circumstances?
Your Honor, it could be because the decision at that point was, we argued and the lower court agreed with us that we had in fact put in what would be equivalent of an affidavit of service under 302. So under those circumstances, there was no reason not to at that point, and the lower court did agree with us. So it wasn't that we were doing anything improper by doing so. And if I might, just so, and as to Your Honor's question as to the stipulation, there was very specific carve-out language. And the second part of that sentence says, without waiving any right to any relief sought in the underlying motion, which was the motion for default, among other things. So it was specifically preserved. There's no question about that. It was the first half, it was right in the top of the stipulation. In fact, the original stipulation was modified with the consent of counsel to add that caveat. I thank Your Honors for your time.
Thank you.
Thank you, Your Honors. Very briefly, first to address some of the points raised by respondent, the case law and the statute, which was cited earlier in the oral argument, is explicitly clear that this was not an appearance. Registration to NICEF is not an appearance or does not serve as a notice of appearance. Additionally, even if the stipulation is construed to reserve the right to renew and re-argue, it was filed late, almost 60 days after the real notice of entry was actually filed. Third, there are two cases which are cited in the appellant's brief, which I didn't get to discuss, and I would like to very quickly. The first one is Security Title versus Wolf, wherein the defendant entered into a stip to extend his time, even though he had not yet been served, and the court ruled that this waived any default and was the basis for the court affirming the order denying the entry of a default. And the second one is Simpson versus Apertivo, which is a First Department case from 1983 and also a defamation case, wherein the court found that a stipulation to extend time that was not even signed, it was considered quote-unquote open between the parties, combined with clear lack of intent from the defendants to not abandon the defense, was enough to deny entering a default. And as Your Honor has touched on briefly, and I would like to just reiterate, we have not abandoned our defense in this case. We have...
So counsel, my question to you then is, why didn't you ever just cross-move to extend your time? You get a motion to re-argue, please enter the default. Why not just cross-move to extend your time to answer, cover all your bases, belts and suspenders? Why didn't you do that?
I think we essentially did do that, Your Honor, because once the default was denied on the original...
I didn't see any cross motion. Did you make a cross motion?
We did not make a cross motion, but once the original order prior to renewal re-argument denied the default, we entered into the stipulation allowing us time to respond to the summons and complaint and then timely complied with that provision. So while it wasn't a cross motion, we took action that had the same net effect. Additionally,
File an answer.
I'm sorry, Your Honor?
You received you received an extension of time to file an answer. Did you file an answer?
Well, it wasn't to file an answer. The stipulation explicitly says to respond to the summons and complaint, which we did by motion to dismiss within that same time period. And then the court ruled upon that motion along with the order being appealed from here, denying that motion to dismiss as moot in light of the overturning itself on renewal re-argument for the default. And lastly, I would just like to mention that it is well settled that this court does have a broad authority in the interest of justice to vacate a default, especially in a circumstance where a defendant has evinced a clear intent to defend himself against the claims in a case and has not abandoned his defense in any manner. Thank you, Your Honors.
Thank you both.
AZ versus City University of New York.
Good afternoon, Your Honors. May it please the court, Daniel Dugan for the appellant AZ. In this situation, appellant is a transfer student from Pace University to respondent City University of New York at Hunter and commenced this instant Article 78 proceeding, challenging respondent's arbitrary and capricious decision.
Why is it arbitrary and capricious for CUNY not to accept the 9 credits? I forgot 2 Spanish classes where he received, I think, a D- in each, and then a freshman orientation class as well?
Yes, Your Honor. In addressing the Spanish transfer credit classes first, CUNY applied a rule that is in their transfer credit policy that requires a C or better for students transferring from outside of a CUNY school. The distinction they make for CUNY students themselves is a D or better, which is essentially...
Counsel, why can't CUNY do that? That is the question. Why can't Hunter College do that? The policy is announced. It's the Hunter transfer credit policy is very clear and it's available. Why can't the school do that?
It is. But on its face, it violates the rules of the Commissioner of Education from the state of New York, which is that these policies need to be applied uniformly. And while schools can exercise...
Counsel, isn't the uniformity established where the policy states in the second paragraph, credits will be granted for courses with a C or better, D or better at CUNY institutions?
Yes, so D or better at a CUNY institution is a distinction between credit or no credit. It means if you receive credit for that class at CUNY, you get credit when you transfer. The petitioner, the appellant here, received credit for his class at his school. Now, he did not receive credit for that class.
But it's not really an issue of credit, it's an issue of the grade, right? Because if you were transferring from another CUNY institution and you didn't have the grade, say you had a D or something, that you still would not be able to transfer into Hunter. So it's not an issue about credit or no credit. In this highly publicized policy, which is, as my colleague said, readily available, Hunter College is able to distinguish how they want to accept students because they are able to evaluate better with CUNY schools, correct?
Correct. So in addressing that, CUNY has, as part of its transfer credit process, which appellant undertook here, a transfer equivalency form that needs to be filled out. So while a school has to still have a rational basis for the rule that they publicize. Just because it's publicized doesn't mean it's rational. Here, if there are concerns, and I understand that the school has academic deference to make these academic determinations. Here, their own faculty reviewed the classes in question, specifically these Spanish classes, Their highly trained Spanish professors looked at the two syllabi and said these courses are equivalent. So if a student received credit for that class at CUNY, there's no rational basis for a student who received credit for that course at a non-CUNY school.
But those professors are not the ones who make the determination as to whether something is, whether a class is going to be, a grade is going to be accepted or not accepted. I mean, they're not that decision-making board. These are just individual professors, right?
So that decision-making board, as part of this transfer credit process, which is where this rule is stated, there's a process which is undergone where the transferring student brings this form to the department that he's seeking to transfer the credits to. So if it's science, you go to the science department. Here it was language, Spanish. It went to the language department to review the classes that they have at CUNY versus the classes that he took at a non-CUNY school, and they signed off and said they were equivalent.
But is the decision-making body, do they have to accept the sign-off by the individuals in the language department?
It is part of that process, and their department signed off on it. This was a motion to dismiss that was made by CUNY. There's no other rational basis set forth other than just the policy as to why they made this decision.
Is there anything that says that is there anything that says that when these professors or whomever in that department sign off and say that it is comparable, that therefore the deciding body in terms of transfer credits have to accept that?
No, as part of the process, it then goes back to the Office of Admissions. It does not state that, I'm sorry.
No, go ahead.
It doesn't state that it's going to be reviewed again by somebody else. It's reviewed by that department and then submitted by the transferring student. There's not an indication otherwise that it's going to be then reviewed again. They leave that up to the department. Thank you.
Good afternoon. I'm David Lawrence III. I'm an Assistant Solicitor General, appearing on behalf of Respondent, City University of New York.
Okay, so these professors signed off and said that these classes that were taken at PACE, the two Spanish classes, and we haven't even dealt with the other class, these professors signed off and said that it was comparable. The classes taken at PACE were comparable to those that were given at Hunter. So therefore, why would it not be arbitrary and capricious based upon their decision?
Your Honor, the course equivalency form goes to whether the content of the courses is equivalent. It does not go to whether the academic and grading standards of the courses is the same. CUNY is not familiar with the academic and grading standards of non-CUNY institutions. Therefore, it rationally requires higher grades from persons coming from outside of CUNY because of that lack of familiarity. And that's something that we raised at.
So counsel, are you saying, for example, that you don't know whether any other school requires their professors to grade on a curve or to automatically have 80% of their students in the middle group, or any other policy that any other university might or might not have with respect to grading? Is that your sort of reason for saying we're only accepting a certain grade above for non-CUNY?
It's broader than that, Your Honor. It's not simply whether somebody grades on a curve. It's also the difficulty of the academic standards that the university has and the difficulty of the grading, whether it's on a curve or not.
So, counsel, you're saying that if you went to, I don't know, NYU, where I went undergrad, and, and I'm transferring to CUNY, that you would not accept the credits that I received at NYU and CUNY?
Not
CUNY's
a D, anyway.
policy.
Okay, or a Harvard? Yeah, a D, if I got a D. I would never get a D, but anyhow, you wouldn't accept those credits? Or if you went Harvard undergrad, you wouldn't accept the credits?
Okay, in the first place, Your Honor, because CUNY doesn't make an evaluation of all the hundreds of institutions from which somebody could transfer, that's why it has this uniform policy. In the second place, the policy leaves room for exceptions. Thus, the Senate chair stated in her decision, she found no reason to depart from that policy here, but there could be a circumstance in which the Senate chair could find some circumstances in which it would be acceptable to depart from the policy. But the general policy is because, as I said, CUNY is not familiar with the grading and academic standards.
But the bottom line, counsel, is that you have a policy. There is a set policy, and it was followed in this particular case. Is that correct?
Yes, Your Honor.
You want to briefly address the issue of the freshman orientation classes?
Yes, Your Honor. The syllabus for the class that the petitioner took at Pace University reflects that it is a freshman orientation class designed to orient students to college life, in particular to life at Pace University. The transfer credit policy that Hunter follows specifically says it does not allow credit for orientation courses. So therefore, it's entirely rational for the Senate chair to find that.
That's with respect to any university and any college, period.
Yes, and that even includes any other campus of CUNY. Those sort of courses are not going to transfer credit.
Thank you.
I just want to briefly address there's also the Exploring Majors and Careers course, which is the same situation, where the transfer credit policy says that Hunter will not grant transfer credit for courses that deal with career exploration. And the syllabus here from Pace University clearly shows that it is a career development type of course, getting people familiar with potential careers, exploring what they might like to do for a living. In any event, the determination whether these courses fall within that transfer credit policy, that's an academic determination. That's the sort of determination for which it's well established that the courts give deference to the universities. And finally, I'll just note that the petitioner had notice of the policy, the transfer credit policy, at the time that he transferred to CUNY. The policy was on the CUNY website. He is deemed to have transferred with knowledge of that policy and subject to that policy. Unless the court has any further questions, I'll simply ask the court affirm the judgment dismissing the Article 78 petition. Thank you.
Thank you, Your Honor. To touch briefly on the issue of speculating as to whether other schools may have different academic standards and whether that was the reason for this policy, that's not in the record at this stage. In making the determination and when the Senate chair denied the appellant's appeal internally, they simply stated this is the policy. They didn't offer a rationale as to why, why the different standards applied. In the Supreme Court's decision here, it was speculated that the school could have thought that. This isn't their stated rational basis. They moved to dismiss this petition. That information and why this policy is there is not in the record. It's just speculating as to it could have been a different standard. Moving and touching on the Senate chair appeal process, I do just want to note.
If the policy is applied uniformly, irrespective of whether you went to Pace or Harvard or NYU, then why is it irrational?
Because on its face, it violates the Commissioner of Education regulation that you just cited, and a policy, just because it's stated, there still has to be a rational basis for it, and we don't have that here. If there was an academic concern, it's addressed by their own faculty review.
Why is it arbitrary?
Because the courses were deemed equivalent by CUNY itself and their experienced faculty. For that same class, a student at CUNY transferring within CUNY receives credit for that class. It is arbitrary to deny a student from outside CUNY credit for that exact equivalent class. And then just touching on the Senate chair appeal process, the Senate chair took into consideration without informing.
If CUNY were to have a policy that they weren't going to give credit to any transfer courses, would that be irrational?
No, because it would be applied uniformly to CUNY transferring students and non-CUNY transferring students. So all transfer students would be under the same policy. Here they're making a distinction, and they need a rational basis for that distinction.
Thank you, Councilman.
Thank you, Your Honors.
Powers versus River Center.
Good afternoon, may it please the court. Mark Kajowski for the appellant. This case involves the failure of a large makeshift device that had been assembled at a construction site for the purposes of holding several hundred pounds of carpeting 3 feet off the ground so that it could be rolled out. There is absolutely no dispute that this device failed. It collapsed, and there's further no dispute that as a result of the collapse of this device, hundreds of pounds of material landed on the plaintiff. Despite this, the lower court took the unusual tact of dismissing the case in its entirety on a credibility issue of the plaintiff, specifically with regard to where the plaintiff was at the moment the assembly collapsed. The plaintiff's affidavit clearly states that he was standing on top of the 2 buckets, which were used to hold up this
Well, isn't it relevant as to where he was standing, whether he was standing on top of the apparatus or whether he was standing on the floor?
Your Honor, I believe that Mr. Powers is entitled to the protection of 240, whether he falls off of the failure of this contraption or whether it simply lands on him. Under Runner, he is entitled.
Counsel, did you argue that he was entitled to 240 because it landed on him?
Yes, Your Honor, we did.
You did?
We did. I believe that we cited in the footnote in the reply vote.
Okay, but I'm not talking about a footnote. I'm talking about, did you make that argument?
We certainly did, Your
trial
Honor.
court?
It's a Colbeck type argument where, in Runner, which of course the court relies on, which means you don't have to fall or be struck. But that's absolutely the case, Your Honor. This is a very unusual situation where, frankly, the motions, after years of this litigation had been going on, 2 parties looked at the case in an entirely different way. And I think that had a lot to do, frankly, with what was going on with the depositions. It was, for example, one of the things that kept coming up in the motions in the brief dealt with this "I was next to the carpet" type of description. Mr. Powers says, "I'm next to the carpet" because he says, "it's in front of me." And he has that in his mind that he is on top of the bucket. He is next to the carpet, but he's on the bucket.
Well, counsel, we don't know what he had in his mind at the time of the deposition. We know what he testified to at the time of the deposition. And as my colleague just pointed out or stated, that was not the thrust of the argument. The thrust of the argument in terms of 241 was whether he was, again, standing on the apparatus or whether he was standing on the floor. That was the thrust of the argument, and that was the thrust of the argument made in Supreme Court.
Your Honor, respectfully, and again, I cite to it because I know that they raised that on an issue. We cite the Colbeck case, the Runner case. The court relies on Runner. This is very similar to Runner, where you have a very large thing. In Runner, it was, I believe, a 300-pound wire coil, and it's just being lowered just a couple of steps. In this case, you have hundreds of pounds of carpeting. This contraption they built is acknowledged by everyone to be unsafe. The site safety officer, plaintiff's undisputed expert testimony that not only is this unsafe, because it's going to collapse, but that there are other devices available. The fact that in the respective motions for summary judgment and op, there was different ways to attack 240, one of which is he fell or he got struck.
My point, Counselor, was the fact that Supreme Court based its decision on the inconsistencies, I guess, from the plaintiff in terms of exactly where he was standing.
Yes, I agree with that, Your Honor, and I believe that to be completely unusual and inappropriate in this situation. The lower court, and
Well, no, wait, 1 second though, counsel. If he was standing on the floor
yes.
and you didn't specifically argue that that was a height problem regardless of where he was standing, why would the Supreme Court do anything else?
Your Honor, I think that the focus of the, first of all, we did argue that.
Oh, we're in a footnote, right?
No, I believe in the
I read
reply
your
brief.
briefs.
I'll put it in there. I'll get you the site during
Okay.
my time for rebuttal, if that's okay. What ended up, the focus was simply about the collapse of this device which injured the plaintiff. It has always been that. The position of the plaintiff immediately beforehand, frankly, is a distinction without a difference for the purposes of 240. Under Runner, he is injured as the direct result, the direct consequence of the failure to provide adequate protection against risk arising out of physically significant elevation differential. Indeed, the entire discussion in the underlying motion, which cites Colbeck, which is a fall-down case, and Runner, which is a callback case, says he's also struck by a falling object. Of course, that's not what happened here. I mean, he is ultimately struck. You can look from the pleadings and on, he is struck by this hundreds of pounds of carpeting. That is undisputed.
Because the bucket collapsed, correct?
The entire, I believe
apparatus, whatever
the
it was.
whole thing. And again, it's several buckets stacked up. There's a 8-foot pipe they find laying around the construction site. This is exactly the type of risk that 240 was designed to avoid. These sort of makeshift things that can cause considerable harm. And the fact it's the analysis in Runner, which was argued below, it was argued in brief, deals with the very simple repeated discussion about whether or not this risk was posed to the plaintiff. And given the weight of the material, and this court has been repeatedly clear on that, it's not just the height that it falls, it's how much does it weigh, because it's the risk that it poses. And that's what this is about. This is a makeshift scaffold that was apparatus that was incredibly unsafe with a lot of weight, and it landed on the plaintiff. The defendant can make all these arguments about where Mr. Powers was and what landed on him at the time of trial, if this court deems that appropriate. They can cross-examine him about when you said you were next to this or next to that. That's completely appropriate. The plaintiff's affidavit clearly lays out what happened. The plaintiff's expert clearly lays out what happened, and common sense dictates this is the type of hazard that is intended to be avoided under this statute. Whether he falls from the bucket or whether he's struck by the bucket, the same law applies, and that's what happened. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Dennis Heffernan. I represent the defendant respondents in this case. The plaintiff's sole opposition to the motion for summary judgment in this case was to try to create a scenario that would fit within the parameters of 240. So he came up with this affidavit that had nothing to do and had no reflection of the prior testimony. There is no testimony in this case, in 3 depositions, that Mr. Powers at any time was standing on anything other than the ground.
So, counsel, a basic question.
Sir?
Are you arguing that the accident was not elevation related?
We're arguing that the accident was not elevation related. Just as Justice Kotler pointed out in her decision, this is not one of the hazards extraordinary hazards, as the Court of Appeals has always said, that 240 is designed to apply to. Mr. Powers, at the time of the accident, is standing in front of a bucket where they're pulling the carpet. And as they're pulling the carpet comes forward and hits him. And so, it's an unfortunate accident.
So stop there. So if the carpet is elevated, I'm going to use the word elevated loosely, all right? If it's situated on top of buckets and that particular construct is such that those buckets can't hold the carpet, and boom comes the carpet and it hits somebody,
Well,
Is that not elevation related simply because it was on buckets, which means it was off the floor?
It is off the floor, Your Honor, but that doesn't make it elevation related so that it fits under 240. Under 240, you have to show that gravity was the reason that the accident occurred.
I'm sorry, that what?
That gravity was the reason that the accident occurred. Here was not gravity wasn't the reason the accident occurred. The reason that the accident occurred is because they're pulling this forward, and he's standing in front of the buckets, and the buckets come down on him. That's not a elevation-related hazard.
Well, Renner talks about a physically significant elevation differential. So would that not be a significant elevation differential?
I submit it's not, Your Honor. There are all sorts of cases that find that this type of elevation differential of about 3 feet is not a physically significant elevation differential. The Eddy case, which is a second department case, and it's a similar type of case as well, where the plaintiff was sitting on what's called a manhole grate, and as he's sitting on the manhole grate, it slides off of the back of the truck and hits him in the head, and he suffers a serious injury as a result of that, and it comes down about 3.5 feet. But the court found that this was not an elevation-related hazard because it was moving forwards towards him.
So counsel, let me ask you, you're saying to us that if the carpet was just being pulled on the floor, the same accident would have happened?
Your Honor, I'm not saying to you that it would or would not have happened.
Exactly. The reason why the accident happened is because the carpet's lifted up on a bunch of buckets.
The case law,
if you're just pulling the carpet along on the floor, the buckets aren't going to collapse and the carpet's not going to fall on him, right?
But Your Honor, beside the fact that argument was never preserved on appeal,
counsel, that I asked counsel, he said he did preserve that argument.
Well, if you read pages 606 through 611 of the record, it's his affirmation in opposition, and that argument's not raised at all in his affirmation in opposition. But nevertheless, Your Honor.
All right, let's assume that we agree. Let's assume we say it's raised or it's enough preserved.
It's not enough under the case law, and we cite all the cases in our brief. It's not enough simply that gravity does play a part in the accident. I can't tell you that gravity didn't play a part in the accident, but it wasn't the causative factor in the accident.
So again, you're telling me that if they had just been pulling this carpet along the floor, that would have caused the accident? Because that's hard for me to believe.
But in this case, it has the same lateral movement. This is a lateral movement case. It has nothing to do with nothing's being hoisted, nothing of that nature.
Well, if nothing less, would that not constitute an issue of fact?
No, Your Honor, because under the case law, this is not a gravity-related incident. The case here, Mr. Powers is pressing down he's standing next to a bucket, pressing down on what he said, as he originally described, pressing down on a pole, and then something falls on him as it's being moved forward. That's not a gravity-related incident. That's simply an ordinary hazard of construction as you're out in the construction.
What made it fall? How did it fall? It wasn't gravity.
It fell, Your Honor, because it got pulled forward.
You're missing my point.
Thank you, Your Honor.
Thank you.
Just very briefly, Your Honor, I found the site at 635 of the record where it was raised below. And I would just like to point out this department's case regarding the issue about the lateral movement. I think the best history of the post-runner description of all the case law in this case is the Mcrae case, 106 AD 3rd, 408. It sets forth how the size of the object that falls is demonstrative. In that case, it's on a little cart, and 1,000 pounds of piping falls off the little cart, which is less than what was elevated in this particular case, and they say 240 applies. And then the Walensky case, obviously it's the same level. There's Court of Appeals, we know that, and Runner. If there's no further questions, thank you very much for your time.
Thank you. You're killing a bug. Let's see who we up to. People v. Arthur Meredith.
We're doing these.
doesn't change it. No, he said it didn't. It does. He said it didn't. Who said it didn't? Joseph. Wrong. Doesn't change. Doesn't change. Whenever you're ready, counsel.
Thank you, Your Honors. Your Honors, Rachel Pecker of the Legal Aid Society on behalf of Arthur Meredith. Mr. Meredith's sentence was excessive, Your Honors. This horrible tragedy and offense were a complete anomaly in his law-abiding life. It was his first offense, his first conviction at the age of 38, and he has not committed another crime or a violation of his supervision since then.
Counsel, was this a conviction after trial, or did he plead guilty?
He pled guilty, Your Honor.
So presumably he knew what the sentence was prior to him pleading guilty, correct?
He did, Your Honor.
He received the benefit from pleading guilty because obviously he faced more time if he had been convicted at trial, right?
Correct, Your Honor.
Okay.
Notwithstanding that, Your Honor, this court has reduced sentences even where the accused have received the benefit of their bargain. And that's because Mr. Meredith here has always accepted responsibility and has incredible remorse for what happened. He cooperated, he pled guilty.
Here the range was 5 to 25, right?
Correct, for the assault one.
And the people's offer was 8, and the court offered 6.
Correct, Your Honor.
Right? So I know that I went back and forth reading the papers here, and what struck me was the fact that there was an opportunity to retreat, and the defendant did retreat. He went behind the door, but he didn't call the police. Instead he retrieved a gun, an unlicensed gun, and then he went back out into the hallway, and the people ran, and he ran after them down one of the stairways, and then he shot downwards. So he shot from an elevation at somebody who was armed with a knife. How does that figure into the excessive sentence argument that you're making?
Sure, Your Honor. He did cause serious harm for which he has incredible remorse, and it's true that he had an opportunity to withdraw and call 911. But that was true of Mr. Fernandez and People Fernandez, this court's case, as well. There, Mr. Fernandez had numerous letters of support attesting to the aberrational nature of a manslaughter count against him. And there, Mr. Fernandez retreated to his apartment. He had the opportunity to stay safely and call 911. Instead, he came back out and unfortunately stabbed.
Wasn't that the one where he had been continually bullied or by individuals in the area that had gone on, in the community, in the building or whatever, that had gone on for a significant period of time?
Yes, Your Honor. And in this case, too, the Merediths had been bullied for 5 years by the complaining witness's brother, who was their daughter's boyfriend. Here for 5 years, the Merediths had been having problems with one of their 10 children. The complainant's brother, their daughter's boyfriend, had attacked Mr. Meredith twice in 2011 and 2012. In 2015, they got into 2 physical fights. They had 1 order of protection out against their daughter. And earlier that day, the Merediths themselves called NYPD as well as the NYCHA Police Department with complaints about their daughter.
Who was the one who threw the belongings and clothing out into the hallway?
The ultimate fight that occurred on this day, the Merediths, Your Honor, Mr. Meredith and his wife, the ultimate fight that occurred was them saying you're no longer welcome in our home because of the harassment that we're suffering.
So the bottom line, counsel, is that your client received 6 years plus 5 years post-release supervision, and you want us to reduce it to, and he's at liberty now, he's no longer incarcerated.
He is,
You want
Your
us
Honor.
to reduce it to 5 years and 2.5?
That's correct, Your Honor, or time served.
So it's the post-release supervision that's really an issue, right?
It's both. If it's time, it's both, Your Honor, because he got out at his conditional release date due to his good behavior. If his sentence were shorter, then the post-release supervision would run from a date that was earlier in time. So both could reduce the time that he is supervised. Thank you, Your Honor.
Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Reva Grace Phillips, and I am here today on behalf of the respondent, the Bronx County District Attorney's Office. Defendant validly waived his right to appeal. The plea court distinguished his right to appeal from those rights.
Counsel, could you speak a little slower, please?
Of course, Your Honor, my apologies. The plea court distinguished his right to appeal from those rights automatically waived upon his plea of guilty. Defendant discussed the waiver with his counsel. Defendant acknowledged his understanding of the plea and waiver on the record. And defendant cited detailed written waiver that supplemented the court's oral explanation. Notably, the court and the written waiver both, as defendant concedes, expressly advised defendant that he was waiving his right to challenge the length of his sentence. Defendant further received an exceedingly fair and reasonable sentence, the terms of which should not be disturbed by this court. Defendant received a sentence just 1 year over the statutory minimum, despite the fact that his conduct includes successfully retreating to the safety of his home before choosing to chase down his victim and shoot her twice with an illegally possessed and defaced firearm.
What about the years of assaultive behavior, harassment, et cetera? I think your adversary mentioned 5 years that this had gone on. The fact that the defendant had no priors and since, I guess, and has not sustained any new arrests, or what
Yes,
about
Your Honor.
all of those factors?
Certainly, and I would respond with a few points. The first of which is, notably, defendant does not allege that the complainant here was the person who assaulted him previously. In fact, defendant's alleging that previously he was assaulted by this victim's brother and by an unattached party, the defendant's daughter. There is no allegation that Kiana Zulu, prior to this time, in any way physically assaulted the defendant. Furthermore, Your Honor, he chose to chase down and then shoot Kiana. He chose not to chase Malik, the person who defense counsel or defendant just identified as the one he had prior physical altercations with. He chose instead to chase down Kiana and shoot her. Additionally, Your Honor, while the defendant has no other criminal convictions, this conviction clearly indicates underlying criminal behavior in that he possessed, at the time of this incident, an illegally defaced and loaded firearm. He didn't get that firearm that day. He had that firearm. He went and retrieved it. And as Your Honors rightly pointed out, left the sanctity of his home where he could have called 911 and instead chose to chase down his pregnant victim, shoot her in the face, and then shoot her again in the torso. Unless Your Honors have additional questions for me, I rest on my brief and ask you to affirm the lower court. Thank you for your time.
Thank you.
Your Honor, if I may just clarify one point. The complainant showed up with the complainant's brother, the boyfriend who had been harassing Mr. Meredith for years, and critically, he went in. It was a fast-moving situation, but the complainant herself wielded a knife and threatened him with a knife, and the prosecution below admitted that in the prosecution memorandum at 2, which was part of the record, and it's cited in my brief at 7, but the complainant herself, unfortunately, wielded a knife that day, too, in response to my adversary's arguments. If you don't have any other questions, I rest on my briefs.
Thank you very much.
Thank you.
And we have Farina versus Katzandanis. Whenever you're ready.
Good afternoon, Your Honors, Counsel, and may it please the Court, my name is Tara Tully. I represent the appellant, Maria Carmela Farina. It is appellant's contention that the motion court improperly granted the motion to dismiss because the respondents failed to carry their heavy burden of utterly refuting the plaintiff's claims and conclusively establishing their entitlement, the statute of limitations defense as a matter of law. I'd like to today underscore just 2 points in support of that contention, if I may. The first is that the determination of when an attorney-client relationship ends for the purpose of tolling under the continuous representation doctrine is a fact-specific endeavor, and this court and other appellate divisions have looked at a variety of factors to determine when such a relationship is concluded. As such, it's not a determination that is well-suited to resolution on a motion to dismiss at the pleading stage, particularly where, as here, The documentary evidence is ambiguous, and it is also conflicting in many respects.
Counsel, didn't the plaintiff sign a consent to change attorneys in February of 2016?
A consent form was in fact signed on that day, Your Honor, but respondents chose not to honor it.
But then they countersigned it in March, right? March 22nd.
At the time that they countersigned, there was a pending order to show cause seeking to be relieved as counsel.
So just stop 1 second. So if you have a consent to change counsel and it's countersigned by counsel, do you need to have a court-ordered stipulation in order to be relieved as counsel, or does the fully executed document speak for itself?
Well, under CPLR 321, the fully executed document would be sufficient. A court order would also be sufficient. The statute doesn't contemplate a situation where both routes are pursued at the same time. And respondents here, by initially refusing to just comply with the consent to change attorney and instead choosing the other route and seeking court approval, but then countersigning the consent to change attorney without withdrawing that order to show cause, created a confusion and lack of clarity as to when the actual representation ended. It's the tolling under the continuous representation doctrine, I would argue, at its heart, is designed to protect a client from being in the situation where the statute of limitations clock is running, but she or he is still dependent on the outgoing law firm to represent their interest. That's what happened here. Incoming counsel, even after that consent to change attorney was countersigned, there's no evidence that incoming counsel undertook representation. To the contrary, shortly after the order to show cause was resolved by the so ordered stipulation, within just 5 days, incoming counsel did step up and attended a compliance conference.
So are there any cases that say that there has to be some type of undertaking of the representation?
No, Your Honor, but there's plenty of case law that says there has to be a clear understanding among all the relevant parties as to when the representation ended. I would argue that the incoming counsel's refusal or failure to undertake representation gives rise to an inference that there was not a clear understanding as to when the representation ended until the open order to show cause was resolved and the so ordered stipulation was entered, signed by all parties and the court, clearly ending the representation of the respondents. And if the court has nothing further, I will rest on my brief.
Thank you. Whenever you're ready.
Thank you. Good afternoon, Your Honors, and may it please the court. Respondents respectfully request this court affirm the trial court's February 21, 2020.
So, counsel, at the outset, I have a simple question. So if the defendants countersigned on March 22nd, 2016, right?
That's my understanding,
They
yes.
countersigned the consent to change counsel, and then 1 day later, on March 23rd, the very same defendants file an order to show cause to be relieved and for a charging lien. Is there a contradiction in terms there?
No, there's no contradiction, Your Honor. When a client fires their attorney or terminates their representation, that happens the moment the client does it. It's absolute, it's automatic. Any sort of action that an outgoing attorney taking is not to preserve that type of relationship. So what's happening is they're getting an order to show cause to enforce the charging lien and just to be removed as counsel of record. But being even as counsel of record, that is not a clear indicia of the ongoing independent relationship between the parties. Our brief argues that that ended when they fired her, or when they fired respondents by providing them with the consent form. And then, you know, as the trial court found, the trial court looked at the last possible date by their analysis that any clear indicia could exist, and what they viewed it as is basically resolving all other disputes besides the dispute as to whether or not the charging lien exists. And so there are a number of different incidents that we've argued in our brief are independently sufficient to find that no clear indicia of an ongoing relationship exists.
So,
First-
counsel, you could have avoided this whole thing by not seeking to be relieved, but just seeking a charging lien, right? Because you signed the document, and then what you wanted, which was a judicial declaration that you weren't fired for cause, you could have just done that by filing a motion for a charging lien and not additionally seeking to be relieved because you had already agreed to that, right? So it's almost like you caused your own problem by that.
Absolutely. Yeah, no, absolutely, they did cause their own problem. But I would just want to put out one point that is a little bit different from what the appellant argued, is that by April 7th, the incoming counsel, they were the ones who filed the fully executed consent form on NICEF. So they had to go on to NICEF, they had to consent to represent the appellants in this action, and then they filed it as part of their representation of the appellant.
The representation would have ended no later than April 7th. Right?
That's what the underlying, that's what the trial court found, and we would ask the court to affirm the same. I see my time is running out, so I just submit the remainder of the arguments we made on our briefs.
Thank you.
If I may, real briefly, Your Honors. With regard to the April 7th date, I think it's worth noting that the record at page 239, there is a compliance conference order from back in February, before all this began, scheduling another compliance conference for April 12th. There's no evidence as to whether that conference was, no evidence in the record as to whether that conference was held or who represented the plaintiff at that
But I
time.
thought the consent to change attorney was filed on April 7th.
Yes, Your Honor, and in that window between the date that the consent to change attorney was filed and the order to show cause was so ordered, there had been a compliance conference scheduled, which I think merits discovery as to who was representing plaintiff's interests at that time. I think there's a reasonable inference to be drawn that at some point in that window between April 7th and the signing of the so ordered stipulation, plaintiff was dependent on respondents.
Well, counsel, wouldn't your client know whether or not they showed up to that conference?
Well, Your Honor,
what discovery do you need? You know whether the lawyers know whether they're there or not. What possible discovery is there? And what I really want to know is once you file the April 7th stipulation, who thinks that this firm is still representing the party? Who could possibly think that?
Well, I think
clearly your clients, the firm, didn't think it. Clearly the client didn't think it because they all filed the stipulation. So who could have possibly thought that this firm was still representing her?
Well, I think there's a risk, Your Honor, that until that.
Oh, I'm just asking you, who could possibly have thought that once you and your client filed that stipulation?
Well, once the stipulation was filed, there was still a question as to who was the attorney of record for the party. And it had the incoming counsel undertaken representation. Any action they took could have been subject to challenge later on based on the fact that the order to show cause was still open.
Thank you. Thank you both.
Right. Thank you, Your Honor. Thank you.
Didn't
Okay,
make us
take care.
last, man.
I've never been last before. Take care. Thanks very much. Have a good day.
You have a pen? Counsel, is your pen? No. All righty, very important tool. Nice pen. Wow, guys. I always want to stay behind after like a boss, you know, like the bosses do. How do I look? Do I look professional?
They got new cameras.
The mic is still on, the cameras. Oh, I'm sorry.